Yes, Kohima Benz. Am I audible?
Yes, my lord.
Yes, where is the petitioner?
Your Lordship, the petitioners have not turned up.
Same thing happened on last occasion also.
Yes, Your Lordship.
You are representing the state.
Yes, I'm for the state respondents.
And what about the private respondents? We asked them to issue notice and all. We have asked for justice service also. Okay, though the state council is represented, none appears either for the petitioner or respondents. Nothing is available on record to show that any justice services has been taken and affidavit has been filed. In that view of the matter, let the matter be listed. Let the matter stands adjourned. Registry to list the matter only only when the learned counsel for the petitioner or the private respondent makes a mention. Full stop. Yes. Item number? Okay. Some office notes, what I do not, I have not. Now we are above.
Yes.
That is the difficult. Now, so it will be now slow. Have you gone through it?
No.
Will you have time to go through it and come back at 2? Yes. All LCRs. Or what? This is what he seeks an adjournment. Any case there?
No, LCR is there.
26. Then if okay. Stand adjourned. LCRs are scanned copies, isn't it? Okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned for? Huh? Adjourned for 2 weeks. Be inside or AV. Any interim order? Interim order. Interim order, give a date. Whenever interim order, give a date. Absconder or what? Third secret. 13 September. 1-3. Yes.
With the consent of the petitioner, kindly allow us to use the filing activity.
Item 45. Who are you?
I am the respondent on behalf of A. Kapra.
What affidavit do you need to file?
Actually, the petitioner has falsely negotiated the power of attorney and some other documents and sell the land without my consent.
Okay.
That's why
So we'll pause it. What kind of affidavit do you need to file? Specific allegation is that signature has been forged. Investigation will take place. That's all.
I have filed the FIR in Delhi.
Okay, if you want adjournment, we will adjourn it. Yes, on the prayer of the learned counsel for the respondent, matters then adjourned and be listed after 3 weeks. Interim order, if any, shall continue.
I'd like to mention item number 49.
Okay, why?
PD was also, the PD has not been.
So you cannot wait till the matter is solved.
I'll wait.
Huh?
I'll wait.
Yes,
Please, 31, 33.
30,
In 30 and 33, there is no. 30 is from Orupakar.
mm,
There is.
30 when? When? 12th of September, any interim? Interim. Then 33,
33 also interim manner.
mm,
Then
12, 33. And what is the other?
it's 32, 31, 31. Any day one of the days was not.
Okay, when? Day after tomorrow? No, not Thursday. Yes, huh? 30th. Those CDs available, the learned counsel for the petitioner is having some difficulty and accordingly prays for an adjournment. Prayer is allowed to release this matter on 30th of August 2023. Interim, any interim? Interim order, pass earlier shall continue. Listing of pending matter, what? Criminal appeal, criminal revision, huh? You make a mention before the senior bench, isn't it? Court 9, go to court 9. Yes, Madam. Yes.
Regular being more than 7.
When?
Tomorrow. Obliged.
Huh? Withdraw. Dismiss and withdraw. No? Under prayer of the learned counsel. Motion item 2.
For motion B, item number 1,
CD. Eight.
item number 2,
Withdraw.
item 3,
Yes. Where is the affair?
My mother has lost the environment. And Vicky is also my is parents for a
To the satisfaction of
mother.
Shizia, Borpeta, 25,000.
item 4,
Yes, CD. When? 11.
item 5,
None appears for the petitioner. Call for the case date. When?
I come upon another 8
8.
Item 6,
Yes, Pura, we'll call for the CD.
Already more than 30. We logically see the extramarital affair
Hmm.
does not constitute an offense of 306. Extramarital affair.
No,
has to be, something.
Something, some proximate.
But approximately there's a long relationship logically C1, the page 8 FIR. The admitted fact is that the second part of the FIR,
Where is the affair?
the FIR is the logical find at page 12 by the vernacular. Second
FR page.
Page 12. The vernacular portion. That's the reason for committing suicide, that is the second paragraph. অভিযোগ জানাবো বিচারকে আজি কিছুদিনৰ পৰা অন্য নাৰীৰ লগত সম্পৰ্ক থকা ঘটনাবোৰ ছোৱালী যদি
But
গম পায়,
the continuous torture may also be a cause.
that means that's a foreign-issue, that's a different issue.
But can't then be a ground for compelling her to that cruelty?
No,
Will not that
there
proximate?
has to be continued and abatement. Because the second part is more important, my lord. The reason for committing suicide, not for the other reason, it was going on, that's a different issue. But the second part,
We'll call for the case there. When, from where?
from Kamlo, it's full, my lord.
Give a short date.
Eight.
8.
Problem.
item 7,
Item
7.
302, along with postmortem report. Call for the case diary along with the postmortem report. Yes.
item 8,
Yes.
51 days.
Huh?
51 days.
So, what is the period? Total
409 is 590.
90 days.
Number 11.
Page number. Oh no, I will not. CD.
In the office by lot, we are not in the is transferred to another.
Okay, let us reject this then. Huh? You want a rejection? And where are we?
item 9,
You are the postmaster or the peon? Ah. Yes, item number?
Yes, 9.
9,
But here was the request was there, like I am for 2. And was the one 4 person was the only one
Ah. Go to session judge. Go to session judge, withdraw it. Case diary with injury report. With item number with medical injury report. With injury report. 11.
item 10,
CD. CD. When? I think Hyderabad is something like that. Isn't it? Fake currency. When?
item 11,
What was this? The college teacher. What is his role?
There is no role, the only thing is that he has given 5,000 to the Dilip Kumar Pal in the year 2014. He was there in duty for 8 months.
Yes, I've seen that, I've seen that. What is your period in Dhubri?
The period in June is about 8 months, madam.
How many days you are inside?
And now from 17, 8, 20.
17, 8. All documentary evidence. Who signed, who signed. This branch manager is already how many days?
17, 8, मतलब ये about 11 days. 15 days.
And he was not in during that. Actually, the situation, what happened, he was a period of your period was 8 months, and the main allegation that did not happen during his period. Some fall,
Oh,
yes, considering the period of detention only, not necessary, and also. But problem is that moment we give it, the poll will come.
all is not there. All direct evidences are there.
Poll will-
Forwarding the poll.
When can you produce the case diary? Day after tomorrow?
Yeah, you know, yes.
Day after tomorrow, okay, be 1 day more, day after tomorrow. Okay, let them also have the satisfaction. CD 30. Have it. Then at least it will not be on your blame on you. We will go through the case there. Yes.
Motion AB, item 12.
Madam, still please second against the listed.
Huh.
So, along with Muslim group, don't have to file. I'll.
It's a case of interim. It's a case of interim. Pankaj Kumar Musari. Are you having the case there in this case?
I don't have any.
You don't have.
case study of the,
Till the report comes. Okay. Okay.
Item number 13.
CD. So he'll take 500 rupees, 200 rupees, all these people.
I have categorically stated how much, how many houses have been, so far.
Let us have the case.
This is why I'm paying for, stipend. Because-
There is specific allegation.
And furthermore, also he is a member of the government from the.
So-
And this format, he contested from some market.
So
This is the political rivalry.
where is that? Mere political rivalry will not be a ground either to cause or to grant interim when case is made out. Absolutely. A poor lady, see, you are taking money.
62,471. And for 2023, houses have been constructed so far.
These people are waiting. You are the they represent. You are represent
We will get
Sit-
care about it.
city.
How deep will it be?
That will be given by
Up for 15 minutes. 15 minutes.
13.
Item 14. For motion.
Yes. FIR is silence.
Yeah, by the girl.
FIR is silenced by the victim herself.
Yes.
All for the scanned copies of the case diary as well as record no? From the learned court of not sensitive. Okay. Call for the case diary. This is AB or Quashing? Quashing. Quashing. Stop. Case call for the case diary. What is your ground?
Ground is that the FIR has been filed by the father matter.
What was your age at that point of time?
I was minor. I was minor. But
Then
the allegation whatever brought by the father matter are not correct. There is to be
when,
examined on that.
what was your age on the date of marriage?
14 years.
On the date of marriage.
Marriage is the largest affair.
What is the age?
14 years. And as per that, the other side also, the argument. Now 15, the other side also.
Now also 15.
And now because we have already paid a part.
That is the difficulty. That in
Yes, I know the details of the code also. Just you look at that, because we are not going that Jamni bail in this connect. But here the victim we have herself has come. That
how can she maintain a petition
no,
if she is not a major?
He is represented by her mother. In this case.
What is that?
Yes.
This is plus either we do not have.
Mother.
There is a first item, phase 2, and affidavit.
We will have to admit and list this matter after 3 years.
In this case, because family of husband, practically man. Practically is that who is the father in the side of the.
Whatsoever, we assume that everything is false. There is no rape, nothing of that. But itself, marriage itself is difficult. 15 years. 15 years, she needs care and protection. She needs care and protection.
I agree.
Huh?
So
She is not even aware of what decision she has taken.
Yes. I know. He also examine and
Mr. Parasa, see the page 21. These happy moments is difficult for court to dislodge. Call for the case there. Nobody will arrest you. Cause for a case there. Huh? Notice. And he will come and file an affidavit that out of gas I file this. Then we'll post it. And then, okay, notice to the respondent number so. Hard, this is an application under Likiva. Issue notice returnable after 4 weeks. Mr. Parasar accepts notice on behalf of respondent number 1. Mr. Parasar shall produce the case diary on the next date fixed. Give a date returnable. Huh? 6th of October. Notice to be issued to the respondent number 2 by board case. What interim? Nobody will do nothing.
Item 53 of supplementary list.
We don't come against an order of maintenance.
That shows that the opening argument says many things.
But here, madam, some statutory, now, guidelines that here in the video judgments of the Supreme Court. If you're not-
What is about this? This is challenging.
Basically, the difference of the husband is that, that they.
You want a quashing of DV proceeding.
I think, you're also find the interim order at page 77 and Excel 6. Although I would not say it is an interim order, because if I say it is an interim order, then 397 bar will come. Now, any order of maintenance, whether it is interim or final, under section 125 is now even a new nomenclature that is intermediate order. So we filed an application under section 94 of the 74 but the High Court restricted that you have to file it under 397. That's why we filed it 397, dated 1904 of the Federal Court Act. Here the main grievance is, madam, today in any of the courts in Assam, especially in 125 for proceeding, in terms of the Neha versus this case.
What do you do? What is your profession?
Madam, the court should have taken account of the assets and liabilities of both the parties.
Both that we are nothing. But my first question, what is your profession?
I'm a constable.
You are a constable.
Yes.
What is your salary?
My salary at the time when because just simply put me a question, what is your salary? On the day when this order was passed, it was 40,000. Now it's 45,000. But the judge has recorded it 50,000. But there are certain deduction, compulsory deduction in my salary. My take home salary at the today is 17,000. And out of that,
Take home salary means loan after loan and all.
Yes.
No, that will not continue because you have option and asset.
That's why we don't say in all these cases, or the honorable Supreme Court, that we have to take the assets and liabilities of not only the husband, but of the opposite party.
Party.
And then come. So, Malad, the next date is fixed on 7.
Hmm.
Malad, till then, Malad, your lordship will ask the family court to take the assets and liabilities of both the parties and come to a proper finding. It's not that.
Why are you saying that they will not do? This is an interim.
No, this is an intermediate order. But it is.
This is an intermediate order. You will have
No,
to.
no, Malad, before even granting an insurance, the assets and liabilities of both the parties has to be taken. And that is done in almost all the courts of assignment now. Except I don't know why the learned judge, and the problem in the family court is that they don't allow the parties to do even into the.
So your limited grievance is that let there be an affidavit in terms of Neha and Rajnish by both the parties and let thereafter be decided. That is your limited prayer. Next,
Next date is 7 of September. We'll file the assets and liabilities on the date. The opposite party also did not file. The learned judge has not recorded it, but it's not. Let both the.
hard
parties-
Mr. B.D. Kaur, Learned Senior Counsel, assisted by H. Vishya, Learned Counsel for the petitioner. The present application is filed assailing an order dated 2/8/2023, passed by the learned Principal Judge, Family Court number 2, Kamrup Metro, Guwahati, whereby a direction was issued to pay maintenance amount of rupees 13,000 to the petitioner. The limited grievance raised by the petitioner is that the aforesaid order of maintenance has been passed on the basis of the oral submission of the petitioner that his salary is rupees 45,000. However, 40,000. How? 40,000. However, Mr. Kaur submits that interim maintenance cannot be decided in that way in view of the dictum of the Honorable Apex Court made in the case of Rajnish versus Neha reported in 2021 2 SCC 324, wherein it is mandated that the assets and liabilities of both the parties are to be taken into note on the basis of affidavit to be filed in framed in terms of the aforesaid judgment. Full stop. Accordingly, he prays that he will continue to pay the present amount. No, we'll 7th is a date. We'll say if that being the limited grievance, this court is of the view that this present petition can be disposed of at this motion stage itself without issuing notice to the respondent wife. Full stop. This court is in agreement with Mr. Argument of Mr. Kaur that to come to a proper determination, the affidavit needs to be filed and assets and liabilities by both the parties are required to be looked into and as laid down, look into in terms of the principle laid down in Rajnish versus Neha Supra. In that view of the matter, this petition stands disposed of, directing the learned family court, Principal Judge Family Court, to ask both the parties to file affidavit in terms of the Rajnish and Neha and to determine afresh the payment of maintenance. Full stop. However, it is made clear that till such determination, we have not interfered with the present award. No, that again I'll have to issue a notice and ask both of you to file an affidavit. No, we'll say, however, while parting with the record, it is made clear that this court has not commented on the merit of the claim of the husband / petitioner that his salary after deduction, he is not in a position to pay rupees 13,000 as awarded. Full stop. The awarded full stop. Therefore, the learned family court is to decide the matter on the basis of merit and on the basis of the declaration made in the affidavit in terms of the principle laid down in Rajneesh versus Naik. Afresh, I've said afresh. Afresh.
What will do? Afresh, the court will say that the High Court has not.
No, we have specifically said we'll afresh in terms of the judgment after filing of the affidavit.
Our obligation will know we have to give, but only they have to do the step.
Yes, dispose of.
Item 54,
54 case. Look, this came was one of- What is this, Mr. Ah, voice sample? Oh, that is permissible now.
As per the decision of the mind of the Ritesh Miller,
Ah, it's permissible.
that is permissible.
Hmm.
I think Ritesh Sharma's judgment by
Yes.
the two-judge consent by this point to be considered.
Hmm.
That was not argued by the man of Learned Council. And that is why man of the Learned Court also, man of Honorable Court, they also need to take this.
Where is the judgment? We kept it somewhere. What to do in this case? That's why we fixed this matter today, but somehow this was supplementary. I could not go through. Can we take up day after tomorrow? Huh? What is the next date?
Fourth is the next.
Fourth is the next date.
Here is on the same point, two of the federal one petition and one judicial petition.
Any interim order there?
In one case, interview.
Where is this was?
That is one of the case, one of last case, man.
Somehow I missed these files because these are supplementary.
I handed over one.
Ah, that is there now I see. But I have not gone through these files. That's why I'm a little bit not so confident like the other cases. It is on fourth. We are taking day after tomorrow. Give me the two orders, interim order. No, that is not there. Here it is only replaced. You have annexed.
You have a CBIS department. And the trial court may have disallowed their man of the court or something. CBI challenge.
This was challenged by page 61.
CBI.
No. Which one page? 64.
Last case.
So here prosecution prayer for voice sample was rejected by the Learned Trial Court. And there was a
CBI has looked at this matter.
CBI preferred this petition.
Subject matter is same. Whether voice sample could be given.
So this was stayed. So meaning thereby voice sample was not taken. Yes, what you say, PP? We'll decide this matter. This matter should not be kept pending. It's a question of law.
No,
Day after tomorrow. Muslim? Huh? Possible? Huh? Day after tomorrow, maybe after motions are over, we'll decide. We'll decide this. We'll start it. Hearing method 50. So you have it prepare for us also. Item number? Okay, we'll pass the order when Mehta reaches. You need not be here.
I already informed the information.
Admission Mehta, not yet. No, I'm not ready for it. Only one admission. No, it's a first control level, not again. First control. They will show admission, then at first control, continuous.
Bail hearing BA, item number 16.
Yes. 57 days. What is the allegation?
302.
What was his role?
He made a mark in the head and in the term, there is a key, right? She will be there and left angel with a cancer between and postmortem report is based on for the because of the head injury.
What was the reason for this fight?
Regarding as per the statement of the accused, he moved more mighty Manajan Kosa Hobitile, and I'm Navabi Vilipaka Mokamadi,
Maybe 304 part. No, just prima facie. So there is no other motive,
No.
not calculated. Both were sitting. So other asked his wife regarding his wife something, maybe some.
And as part of the PM report, injury is less clinical vision, puncture on the left side of the ankle bone, 2 inches to the penis. He might be going inside.
So what do you say? What is your view? What is the stage of investigation? His statement is recorded. Other who are the eyewitnesses? Any friendship? So it was not a premeditated kind of thing. It's a sudden provocation. Okay. Consider hard. The session is in a place and that's when the case diary produced is perused. Full stop. From the material available on record, it is seen that the investigation is at advanced stage, and the petitioner has been under detention since July 29. His statement has thoroughly been recorded. Full stop. The statement of the eyewitnesses has also been recorded. Considering the stage of investigation and the period of detention, this court is of the view that no further custodial interrogation shall be necessary in this case. Accordingly, allowed to the satisfaction of learned citizenship over 50,000.
Item 18.
Yes, what is this? 302. Again.
Here, though PM to be here, but the textual, part of the kept pending till the receipt of FSL. And FSL we could not receive. So now, it is
What is your name?
51 days.
Himanshu Puli. What is the postmortem report says?
Actual cause of death is pending in the recruitment assessment.
Otherwise, what are the injuries?
Injuries, brother, 9 injuries. In the peripheral region. That was the face and all this.
And what are the any weapons? Anything that how this was done?
Aggression, including aggression. So, each takes injury, but, that is-
Any eyewitnesses nearby?
One said that, is he said that more other motorcycle, not our side, typically good, they got not that.
What is your case?
I'll be riding. Then to be like it, I fall down. So, the day we go.
So then why the elevation is lost? What is the motive of lodging an FIR? Otherwise, they would have gone for motor accident claim tribunal. Why? What is the motive of naming you? Tell us that. No, you are saying this is a motor vehicular accident. Then what is your relation with this motor vehicle? Might be there was a motor vehicle accident and you have beaten him up and died. Then will it be a motor vehicular? Then where is the question of accident?
Accident is there because he went the person and was the house of the white. One of the accused, they wanted to capture him. He motorcycle. Run away. During the further accident.
You beat him up
No, did not.
severely.
Because before that he has.
Then you want to give a color of accident.
No. There is no, nothing is there.
Accused statement, I have taken, either.
Even accused persons are not present at the.
What is his statement?
Either statement is there, there are, relation is due to wife and.
The deceased.
Might I action, I don't know, something is there, either police statement. And, he straight away, but one or two statements say that.
No statement of anybody except the one brother.
Now that's one.
What is the name of the hockey? Horenkuli. Okay. But important witnesses or statements are not recorded. The friend of, but it seems it's an accident. Because two witnesses who are no interested, they are not interested. They said that he bike was in a very high speed.
Usually I have seen on the other part, other ones, only station and head and all.
How many days?
61 days.
Okay. About it order pass করেছো. Yes, the return. To the satisfaction of Cesium? Cesium famous. Cesium famous.
19,
Yes, Borboi. Yes.
Often 304 losses. As of today, 30 days in custody.
What is the affair?
When the incident was happened, the petitioner was not present at that time.
Oh, that we cannot decide in a very place. Let us see the affair first.
Page 9 losses.
Yes, what is the case diary? No proximate. Okay.
He was unhappy because she was not
Happy with that. So not
no cases showed that any no cases stated that any number of
how many days?
33 days.
What is that period?
60 days.
60 days. Considering the material available on record, including
what
the
report is not this report is there. Sarah has been also said.
considering the stage of investigation, the statement of the villagers as well as villagers and her, especially her friends, the friend of the victim, and the stage of and the period of detention. This court is of the view that no further custodial interrogation detention is required. Accordingly, allowed to the satisfaction of
City and Hamad.
Cesium.
If you have them.
item 20,
Where is the affair? Tell us first. We have time to read long after, no problem. Where is the vernacular? Hmm. Who are these Scorpio people? Who is he? Who are you? How you are related? Driver of the truck. Scorpio.
Similarly, from whose position you know 24 decks of your students.
Stolen supari from this truck.
Yes.
That so
Similarly,
he is a part of the gang who was involved in that Scorpio. Hijacking the truck.
Taking off the block.
What is the method?
Materials are there again. Only length of station.
What is the total?
Hello?
What is the total?
41 days.
No, in this case, it will be 60 or 90. 60 days. Okay. Considering the length of detention and the stage of investigation. To the satisfaction of CJM Golf.
21,
Yes.
We have received the case results now.
After some time.
22,
Yes. Case. Who is he? Driver of the hijackers.
One from 25 days. Sorry.
How many days?
23 days.
From him,
No recovery.
from other people.
Super is 23 days enough. Don't get involved. Give a last line. The petitioner will not get involved himself in any kind of offenses like this. Next time if we come, we'll monitor and ask them to give charge sheet. That I am thinking in. Second time, this kind of the earlier also you were arrested, released. These people will ask the TP and monitor and so that charge sheet is filed within the statutory period. So that you cannot come out and take it for granted that Abdullah is there, will do it.
There has been recurrence of the.
That is what I am looking at. These are not good signs. We will be strict. To the satisfaction of CJM.
23,
What did you do?
Out of this 6 days, I'm a 21-year-old boy in a love relationship with a 15-year-old girl. The girl wanted to get married. I refused and she committed suicide.
How many days?
40 days.
21 years. What to do? This bench is. CGM?
Okay.
Okay. All 25,000. Except,
Bail hearing, item number 24.
now all these will be heavy. Okay. Where is the FIR? No, give us the vernacular.
I am only for the one.
Any dying declaration?
What is the declaration is not written.
See, she was hospitalized. She would have been the dying.
What's the
On 4th, she took that poison. And on 8th, she expired. She was in hospital from 4th to 8th. We'll take action against this officer. We'll take action. Definitely. So, but there is a report, no, in the hospital.
What's it, the last quotation?
Yes.
Already seen in.
How hospital can admit without informing police this?
What's it? We have already given protection. And the data last quotation, it's directed by the honorable court of the city.
Mm.
The assessment report and modern report. is not-
Forget about all this. Give me the city. What is the statement of the mother who lost this mother and father? They were in the hospital. What are their statements? Anybody examined from the hospital?
From the hospital, but from the nearby location.
In nothing from the hospital, no statement that how she was brought in, any nurse who treated her for 4 days, what she stated before them. And after when it will be acquittal on this ground, you will say that courts are releasing accused. If you do investigation like this, a person who allegation of 306, 4 days alive in a hospital. No postmortem.
Yes, not this. They have said in the last 5 years. And even lordship, the prime accused, the husband of the statement of the husband.
Husband is not prime accused, she is the prime accused.
Yes, he's the that I am going to.
Forget about him. All the persons,
Yes.
all the persons, villagers, neighbors,
The neighbor statement reflect that.
heard. Granite Council for the petitioner. Also heard. Mr. Swenson. His diary produced is perused. Stop. The postmortem report is not available on record. Full stop. As per the allegation, the victim took poison on 4/1/2023 and she was admitted in GNRC Hospital, Guwahati for treatment, but she died on 8/1/2023. Full stop. The investigation so far done by the investigating officer reflects that no statement of any person in the any person involved with the treatment of the deceased victim who was in hospital for 4/1/2023 to 8/1/2023 either been recorded or any document relating to her admission into the hospital are collected by the investigating officer till date. Inasmuch as in the considered opinion of this court, that shall be an important facet of the investigation to to find out the truth. Considering the above, the case diary is returned back and directed to be produced before this court. How many days you are inside? Proceed. Accordingly, proceed and produce the case diary. Give a date as per your convenience. September 13th of September, 30 September 2023. Full stop. Considering the material so far collected, it is seen that the fingers are pointed out to the present petitioner by the villagers alleging serious torture to the deceased. In view of the above, the interim order passed earlier stands vacated, and the investigating authority shall be at liberty to take the petitioner in custody and to have custodial interrogation if so advised. We'll intimate your IO. We'll take action. Forget about that. We'll take action against this investigation. Give an early date. Is it a way to investigate? Oh, forget about that. Including your son, everybody implicated you, everybody. Continuously from the date of marriage till the next date prior. Should we record all this? Should we record all this? Why we are rejecting?
25.
Huh? Who is the affair? Land mafia.
And you have to look at, second variable, that the letting of the occupy our medicinal act.
Yes, what are the
Scheme received, but this is not up to date. Up to date till 29/5.
okay? The Learned Council additional public prosecutor submits that the case that he received is not up to date. Accordingly, he prays that he may be granted some time to get the updated case diary. Prayer is allowed. Please this matter on 22nd of September 2023. Any interim?
Yes, sorry, sir.
Interim order passed earlier shall continue with an additional condition that the petitioner shall not go near the disputed land and disturb the informants.
27.
CD notice.
In interim, it was granted on, interim was granted on 22/5 May. We are in the case diary call for is not received. The interim protection was granted to the petitioner on 22/05/2023 and case diary was called for. However, till date, no case diary has been received. No case diary has been submitted by the IO, though the matter was listed on 19/6/2023 and 4/8/2023. However, on the prayer of the learned additional public petitioner, matter stands again adjourned for production of case diary and be listed on 11th of September 2023. If no case diary is produced on that date, this court may consider direction. It may consider issuing a direction of personal presence of the IO for explanation. List according.
28.
Yes, sir.
Search it being
Docket number 172. It is 25.
in hearing order, so
175,
One.
172 oblique.
172/.
That is only 172.
172 dated
35/6.
interim order shall continue till then. You appear, file application.
29.
Yes.
Here also, the report was very clear that PM report is the conclusive. The number 2 and 3 were getting.
They appeared. Now, you want the case, postmortem report is not there. Okay. The learned additional public prosecutor submits that though the case diary is there, however, the postmortem report is yet to be received. Full stop. In that view of the method, and accordingly, he prays for an adjournment. Where is allowed? Please this matter on 19th September 2023 for production of postmortem report up to the case diary and along with the postmortem report. Full stop. The interim order passed earlier in respect of petitioner number 2 and 3 shall continue.
32.
Some details, there's lots of, court my lord, my last word of also was, we are losing the stamp of your rights.
You received? The LCR, scan copies of the LCR directed to be produced by this court under its order dated 10/8/2023 is not received. Accordingly, registry to issue reminder in terms of order dated 10/8/2023. Full stop. List this matter on when from which place? Which place? Nagaon. After it may not be possible. Again, it will be delayed. There are some vacations. 11th of after 2 weeks. 11th of
34.
Yes. Should be any interim? Any interim? When? If interim is not there, when? 8th of September. No, CB is not this.
35.
Yes. Where is the FIR? Yes.
Here also, PM is not issued this order. And,
So who are you? Who are you, Mr. Abdullah? Huh?
after
So, any injury? Let us see. Any interim? Where is the postmortem report?
How they just folder.
Folder, no folder paper is there. Serious allegation is against you, no doubt about that. Serious allegations, not allegations. Torture like anything, everybody.
The other person
Hmm.
were named that they got really another.
Hmm.
From their state also it seems because
The others are not so seriously involved. This man, husband is,
they also said about.
I have seen not a single witness. Rejected. And will be looked after by others. The way you have behaved, we have serious doubt that you will take care of the child. Child will be in a better in others and rejected. Considering the material available on record, including the statements of the neighbors and others.
36,
বাকিটা থাকিব। Yes, yes. Scan copy received. Okay. Agonist and go order date of 8823. Image to do. Scan copy call. Earlier order was something different. Now it will be 882023. Reminder. Huh? Date will be fixed. Date, give a date after 2 weeks.
19th of September.
19th of September.
37,
Yes. Where is the affair? Hmm? Page 9. We like to read our own language. Yes. What was the date of marriage? 4 years.
4 years.
Yes, what is the
Here we have rejected the here we go after this matter.
Hmm.
Here in the opinion of the doctor matter.
Hmm.
And that was due to especially as a result of antemortem hanging, which was especially in nature.
okay, fine.
But
But-
from the statement of the complaint matter,
Hmm.
even that there is a demand of dowry. But other things, some of the.
So if demand of dowry 4 years, presumption is against him.
Matter. And other. Statement of the acting.
These are not cases for 438. Who can give you 439 on day 1? Be there for something. These are not cases for. Ultimately, a lady out of torture has committed suicide
Matter.
within 4 years of marriage. Demand of dowry is stated, who will say it about demand of dowry?
Complaint.
Villagers cannot say.
No.
The complainant whom demand was made can say only demand of dowry. Why should we go and give an interim protection to these people? What is the presumption? Maybe, but what is the period when a presumption is there? 7 years. And death is unnecessary. Unnecessary, either burn or hang. Somebody says there is a demand of dowry, what more you need, Oh. Some- Rejected. Interim order stands vacated.
38.
Okay. When? When? 21st interim to complete. Sitting notice.
39.
Yes,
But it is not, but on the statement of the gang is there, I have an next one. Our statement, page 20, next photo.
this is 438 or what, AB? Okay, AB. Why AB?
Maybe because he was not disturbed, because after investigation, there was no serious case made up, he admitted him.
Are you on interim?
No.
Where is the victim statement?
Page 21. Silently, just the formality charge is submitted, and I am noticed now.
Someone issued.
Yes.
So go and appear. What is the problem?
Because,
What is the apprehension?
because there is a bar,
What?
307,
What is the bar?
because this is second time.
You go to the session, we are providing it. If someone is issued,
I will, the next time, judgment,
there is no quarrel on that. Cited cases, we can seek. There is no, police will have no interest to arrest today.
Yes.
Your only apprehension is that moment you appear before CJM, offense is not triable by the CJM.
Yes.
Committal court will put you behind. That is your apprehension.
Yes.
We can grant you, that is not a problem. We have the problem.
As per allegation, the application of parents segregated them. They are,
Who are you?
I am boy, a bed, as part our statement, they have did it.
Hmm.
And for parents staying together, the next day morning, my parents came, and she was segregated from me, Then
Separated.
Yes,
Yes,
separated.
yes.
Then father, they lost their head.
Whose father?
Girls' father.
Then now where is the girl?
Now, she is staying with
Parents. What was her age
Page 21, page
at that point of time?
Yes.
Now search sheet is filed against whom?
petition. Page 21, first line,
Page 20.
20, her age is also recorded.
Page 20.
21 and it's not true.
This is a statement under 164. What is her age?
21, my lord, in the first part of the page, my lord.
Okay.
I am also admitting, my lord, we are related, my lord, but she is apprehending, my lord, the father is going to marry, my lord, her elsewhere, my lord. Therefore, she is in hurry, my lord. Accordingly, she voluntarily came, my lord, next day, my lord, my parents came, my lord. A problem arises, my lord, as first statement, my lord, and he was taken by the police. And as per her statement, my lord, police came, my lord, and as per FIR, my lord, she was, my lord, withdrawn from my house. People are avoided and not accepting gratification from our party.
Heard. Mr. So learned counsel for the petitioner. Also heard, Mr. So. The present petition is filed under so. The basic case of the petitioner is that as search sheet has already been filed and someone has been issued to him, he apprehends that committal court having no jurisdiction to try the matter shall not allow him to go on bail, though someone has already been issued. Taking to the statement of the guard, Mr. Borguia further argues that on the date of the alleged incident, from the statement of the girl recorded under section 164 CRPC, it is revealed that she was aged 21 years and she eloped with the present petitioner on her own volition and due to the objection for the father of the petitioner, the marriage could not be solemnized. He further submits that at this any interim order during that have you been searched? Okay. Considering the matter in entirety and also considering the fact that search sheet has already been filed, it will be there will be no purpose shall be served if the petitioner is arrested and put behind the bar. Accordingly, it is provided that the petitioner shall be released on bail of rupees 25,000 in the event of his arrest with the following conditions. No, it is a so. Such protection shall remain till his appearance, till the committal of till the commencement of trial before the learned session judge, and thereafter the petitioner shall apply for regular bail before the learned session judge, who will consider the same on its own merit. This program. Bail. Let us finish up the bills. Huh? Bail. Let us finish up the bail matters.
Item 40,
Sitting office. Any interim?
No injury.
Okay, when?
Don't come under. Because one of the petitioner is already arrested.
14th.
Can it be a 7 or 8?
No, there are some vacations, that's why I think.
7 and 8.
You have that
All entire family is
11.
item 41,
City receipt 41. Okay. FIR is at This is item number 41.
41.
Shri received? Yes, where is the affair? 1-3. Page 13 is a forwarding report. Where is the affair? Who is he? This is the petitioner. Who is Ajibur? Uh-huh. Hmm. Okay, okay. Let that not be treated as a case of murder. There is clear judgment. The moment it is called to be a murder, then the victim, the informant, will not get anything. Yes, we have passed a judgment. Similar cases said that it will not be as a murder. 302 will not come. Anyway, but this is not a case for anticipatory bail. It may not be murder, but this is not a case for anticipatory. Yes. Your name is Gulzar. Your name is there. You are the accomplice of the main. How many cattle you have stolen, from whose place, how vehicle is this, everything is recorded. The way modus operandi, how you do. On last week also 2 cows from these are not a case for anticipatory bail. But you are aware that your vehicle is used for this purpose. That's why you are getting more money. Rejected.
55 supplementary list.
May not be 302, but serious. This is not a case for. In anticipatory bail is a privilege. I always say. Yes, what is your case? Case that you received? Okay. So as the case diary is voluminous, the learned additional public prosecutor prays that this matter may be listed on Thursday. Possible? Huh?
31.
31 8/2023, so that he can go to the same. Prayer is allowed. List accordingly. Interim order pass earlier shall continue till then.
Item number 21, timing matter.
Yes. Case of all case of accident, but LSB murder. Now, till now, 3 cases.
গুরুতর জখম পালো ইঞ্জুরি প্রতিকার swelling on left leg.
Where are the injuries? Which, what?
Injury on left leg.
Okay.
And, for the testing of the और उससे तो मैं जैसा पाऊँ जो है पूर्व में बाइक का आई था तो आई थी ना रास्ते से बाइक से असम में जो है उनके इच्छा की तरह जो उन्होंने उनको बोलेरो करके सुन दिया है ये है मतलब तो जखम बाइक को खुद दिया रास्ते में या खाते हुए काम गाड़ी पर लाखों के मार्केट पूरा चेष्टा करे আমি আই পাউডে जो काम रखा है
One and other, anybody else?
another
Same.
but
PP is in your favor. Any, oh, BA, it's BA. Oh, why should you are wasting so much of time? Okay. Step to the satisfaction. I thought AB. Judicial magistrate, first class, not Sarmanpara, Overpur. Yes. Yes.
For orders, item number 42.
Also, I will journal. Why this matter is listed today? Bokotoki, why listed?
actually it's our announcement. Actually, they are the petitioner and the respondent, they are divorced. And at the time of divorce, when they sign the agreement, they agree that every month the father will take and other increase to the fund as a for his maintenance for his authority. This case was filed. And the honorable court of the going to all the records taking evidence from both sides and upon the income of the as even 16,000 rupees, register 6,000 rupees. This is not satisfied.
What do you do? And what do you do? As the parties are duly represented, list this matter in the admission code. After 2 weeks. Okay. Okay. আর কি আছে? 150 divided by 6. What is the amount? All are bad in maths like me. Yes. Not. 25,000. 25,000.
Area will be cleared by 6 installment.
6 installment within monthly, quarterly, what? If we, monthly. 6 monthly and he'll 10,000 clear, then thereafter we'll hear when we'll hear it. Okay. Mr. R. Ali, learned counsel for the petitioner, submits that the area of maintenance due shall be cleared by the petitioner in 6 installments within a period of 8 months. You said 6 months, I am giving you 8 months. So that no violation, 8 months. And the petitioner shall continue to pay the monthly maintenance in terms of the order dated 22/6/2023 passed by this court. In view of aforesaid submission of Mr. Ali on the instruction of his client, full stop. The matter stands adjourned today and be listed after 6 weeks in the admission column for a final determination. After 8 weeks, on a date to be fixed. You continue and so, in the meantime, if there is any failure on such undertaking, the respondent shall be at liberty to make a mention for listing.
Washment.
Why? Huh?
Forty-four.
Yes.
So that's something that one year petition was whether to place them as a father or not.
Yes.
In respondent, kind of one time maybe can say for final.
This is what is that land grabbing?
Lordship, they are wanted only watching on someone. Someone was issued. And they have.
They can raise their maintainability.
That order also honorable court taken
Hmm.
by this case. Then the case is proceed. Now date is fixed 9/10 for issuing documents. So.
In the land grabbing procedure.
Yes.
And have they raised any objection that suit is pending already? I think that is their ground.
They taking this plea,
Hmm.
but that plea already over.
Okay.
Finally, see the order passed by this honorable court, your honor, my affidavit, my page number 1.
Okay, since matter is proceeding, stay is vacated, there is no problem
Yes.
giving him up.
Only taking this
Okay.
matter.
It is submitted by Mr. M.M. Jaman, learned counsel for the petitioner. On behalf of Mr. S. Samaria, the leading counsel, that some time may be granted to obtain a specific instruction whether the petitioner is interested in pursuing the present criminal petition in as much as the land grabbing proceeding which is under challenge before this court, in as much as the petitioner is participating in the proceeding of proceeding under Land Grabbing Act, which is under challenge in the present case. Full stop. In view of the aforesaid, the matter stands adjourned and be listed on, give a date, next week, give a date.
18th.
On 18th of September 2023, on which date the aforesaid instruction shall be obtained. And on the said date, the learned counsel shall apprise this court whether to proceed in this matter.
Item 45.
Yes. Huh? Whether it's maintainable. What is section 29? DV. What it says? Read that. Read the whole 29.
Yes, a lie, taken to the court within 30 days from the date on which the order made by the magistrate is heard on the street party. Order as it is.
So any order is under 29. Madras High Court says that, full bench says that, first of all, this is not a criminal proceeding. Though a magistrates are taking, it's a nature of civil, so 482 will not be maintainable. I think there is a Supreme Court judgment also, which says it's necessary in civil. Are you aware? Yes, Mr. Counsel, what is your argument? No argument.
I'm acting on behalf of SC Gujarat.
Uh,
Some difficulties. And the agenda matter for today.
and there is a stay against you. Said Dr. See this judgment. We are adjourning it today on his prayer. 2016-11 SC 774. Keep a copy for me also. 2016-11 SCC 774. Kunappa Reddy versus Kunappa Reddy Sarna Kumari. The learned council, on the prayer of the learned council for the respondent, the matter stands adjourned and be listed after 3 weeks. Any interim order? Okay. On a date to fix by rest.
47.
Yes.
There's only one problem in this matter, investment is not. Because the reports have not been called. So since we have to.
Now, what is the stage? What is under challenge?
You know, there are two cases. The
Hmm.
first case was. under-
Before that, yes, ED, are you ready? Okay.
There is a case under the Prevention of Corruption Act
Hmm.
against some of the officers.
Hmm.
Under the welfare, social welfare.
Department.
This was filed long back. The investigating officer has filed a part.
Search
charge
it.
sheet
Hmm.
in respect of one matter.
Hmm.
And it is not, nothing has been done. I don't think that they have been done, but it is one. This case is under the
PMLA.
PML. On the same fact, they take the FIR below the register a case and then. Now, the highway corporate, the adjudicating officer says that it doesn't relate to the money laundering.
Adjudicating officer itself says.
He says that it is not money laundering, that is for its code.
Hmm.
But they prepared an appeal apparently,
Okay.
and that appeal is still pending.
Hmm.
So I am.
Then if appeal is pending, you proceed, you participate in the appeal, then come back to us.
That is right, that thing has to be done there, but
There,
we are not getting any notice from the for the appeal. of-
yes, what about the appeal? Yes, madam, what do you say?
Also, independently filed a petition before the special judge. That
Saying-
is why we have to come. to a
Special just doing what? That
complaint.
complain under PMLA. But how that,
That finding is there that.
because as far as we understand, first is the adjudicating authority. Then there is a provision of appeal. Even if then there is a provision of appeal to this court. Now, if your thing is even if it is held that no PMLA is made out, you have preferred an appeal. You have no instruction. Have that instruction.
And also your logic.
Huh?
Your logic.
Where is that order of adjudicating authority? If you have difficulty today, we may adjourn. Not,
May I say this?
Ah.
Because it is a little confusing.
uh,
Your worship may call for the record of this case. I don't want the prevention of corruption case to come because we are not challenging that. We are challenging only the PML
PMLA case 14 of 2021. The record your lordship will kindly call. Then we will your entire position will be clear and then we will be able to proceed in the matter. I am finding it.
The present criminal petition number 351 of 2023 is filed assailing the proceeding being
Number there, registered there.
proceeding being special PMLA case number 14 of 2021 under first page of syllabus F capital F dot number all capital ECIR / GWZO all capital / 04/2018. This court under its order dated 11/4/2023 while issuing notice provided that while issuing notice state the further proceeding of the aforesaid PMLA case. This court is of the opinion that for proper adjudication, the records may be perused. Records of PMLA case number 14/2021 pending in the learned court of special judge Assam may be necessary. Accordingly, the scanned copies of same be called for proper adjudication. Full stop. You have your instruction. If there is an
I find it very strange.
then if that be so, why should we'll say that that will be determined.
I'm also not sure, therefore I didn't like to
Okay,
say anything. Therefore, let the reports come and
we'll see. Give a date. Registry to call বলে দিব মৌসুমী 5th of October 2023. Till then, the interim order pass earlier shall complete.
So that may be Tuesday or Thursday. That may be. I think.
What is Thursday?
No, then so.
September last, we are also tight.
Item number 48.
Yes. Yes. Your case is that forensic report give a conclusive determination that deed was executed by so and so. Therefore, final report was given. Who are you? What is your case?
There are two cases. One, is page number 18. Page number 18. 1706. In that case, also, both the case are different in nature. One is contravened with the deed of 2341%, and another one is the new one is against the deed of 2349.
There was an FIR. Where is that FIR?
Page 21.
Okay, this is page 21. Where is the
Page 23, 23, 24.
yes.
Friend, this here is forwarded to the police. The police, and after.
See. And deed was executed being 2341 of 2009.
Yes.
According to you, that was not executed by Haranath Kolika.
Yes.
So there is a criminal offense.
Yes.
Police sent the signatures and all to the forensic. Forensic says, no, this is the signature of Haranath Kolika.
Yes. Yes.
Okay?
Yes, yes.
So therefore, criminal liability is gone.
Now,
If you want that it was anything other portion of these that, then you go file a civil suit and get, because you are the, according to you, you are also entitled for that land. And Haranath, in exclusion to you, has given the land to him.
yes, but,
Yes, what is that? But
Yes, yes. The CR case number 7880, this is a present case, so which is select by the petitioner. It is 780/2022. It is in regard to the other, in regards to the deed number 2349. It is not, Lordship, it is not the deed of 2341. Page 39.
now, after final report, you raise an objection.
So final report is separate in regards to deed number 2341. So now it.
Just let me understand. So there was a final report. You file an objection. Then only the CR is registered.
It is for another occurrence. It was in 2349 guilty. Yes, it is categorically stated in page number 39. And also in the primary inquiry statement, which is given under provisions of section 200 of CRPC, it is categorically stated in Annex 7, page 63. It is categorically stated that the number of the deed is 2349.
Where is your FR?
Complaint is here. It is page 39. The relevant portion is in page 39. Can see page 39. It started from 37. Now the relevant portion is 39. Paragraph 2.
What was the case of this FIR, registered FIR case number?
It was registered as CR case.
No, earlier case.
Earlier case was it is
Registered as
1706/27. This page 80.
17.
06. In that FIR also, in page number 24, it is categorically stated that this deed is 2341. Not in the present case.
Where is the original complaint?
Original complaint also page 23. The earlier one was CR 1706/17.
So according to you, on the same day, there are two. Not maybe, it cannot be maybe.
Lordship,
According to you, on 28th of October 2009, Haranath Kolita executed two documents.
Lordship, as
Two,
per-
two give deed.
Yes, Lord. As per the records available in this case, Lordship, it
Where is-
appears that there.
Where is, this is the, after what happened after this case?
This case was after receipt of the complaint, which is forwarded by the court, Lordship, the police investigate the matter. And after investigation, police submit the final report.
Yes, then,
And in the final report, Lordship, after objection raised by the complainant side, Lordship, the case is forwarded as complaint case, Lordship. It is pending before the court, Lordship. Now, Lordship, another CR was filed, complaint case was filed in regard to another deed, Lordship, another number.
we'll record it, that Haranath Kolita, according to you, Haranath Kolita executed on 29/10/2019 two deeds. This is the this number and this is, and if you file that it is wrong fact on affidavit, will proceed under against you under 195.
It is
As clear as that.
No, 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 it is, I am submitting before the honorable court as per the documents which is submitted by the petitioner.
Okay.
Therefore, can you take the matter, in other days, Lordship? But to Lordship, I will, submit all these things because, Lordship, today,
The scan copies directed to produce by this court under its order dated 26/7/2023 is not received. Receives to issue reminder. Police, no? Scan copies is there.
not stand for both the cases.
What both the case?
There are two cases, Lordship. One is, one after proceeding or after.
Everything is there. We'll decide this matter. We'll see if necessary. When? Are you ready today?
No, Lordship, because I have to file my affidavit.
What affidavit in a criminal case?
I have to file my wakalat.
Oh, not yet filed.
Yes, Lordship.
Okay. Learned Mr. Spencer Goswami, learned counsel submits that though he has instruction to appear on behalf of the respondent number,
Two, Lordship.
that should be your first argument. Number two. However, he is yet to file the wakalat. Accordingly, he prays for an adjournment. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by registry. Interim order pass earlier shall continue.
49.
Okay, somebody sought for adjournment. Okay, we have not adjourned because scan copies are not received. Okay. The scan copies as directed by this order under its order dated 17/8/2023 has not yet been received. Accordingly, matter stands adjourned. We'll stop registry to issue reminder for the scan copies in terms of order dated 17/8/2023. List this matter after 4 weeks on a date to be fixed by registry. In the meantime, the interim order pass earlier shall continue.
Item 50.
No, 50 scheme. Okay. Yes. Who is for the other side? Huh? Notice not issued. Heard. Mr. Swenso, learned counsel for the petitioner. The petitioner has filed this application challenging an order dated 19/7/2023 passed by learned additional session judge Kamrup Amingao in criminal appeal number 9 of 2023, whereby the petitioner appellant was directed to deposit 20% of the compensation amount under section 142 or 148 of the Negotiable Instrument Act before the trial court on the next date fixed. Full stop. The learned counsel for the petitioner submits that the provision of section 148 is not a mandatory one, but a discretionary and discretionary one, a directory one, and the issue such order, judicial power should be exercised in a proper manner and with application of mind. However, in the present case, such consideration will not taken. Full stop. Issue notice returnable or give a date. What is the law as on date?
There is some procedural lapse.
Yes. Okay.
Their product has already stayed by this.
In the meantime, we'll ensure that in the meantime, the criminal appeal is completed instead of fighting on that. Accordingly, issue notice returnable on first of October 2023. In the meantime, the learned appellate court shall not insist on the deposit of 20%. However, it is provided that the learned appellate court shall proceed with the appeal to hear in the meantime. Full stop. 3rd of October. Then pay the whole within a month.
Item 43, timing matter.
Yes, Mr. Chaudhary.
Because it's a crushing petition, my lord. So they have filed an affidavit, nothing has been brought up before mine.
According to you, you are nowhere nowhere connected.
Yes.
All this relates to 3 or 4 districts.
Yes.
Only allegation,
Three days.
3 districts, and those are different. You against you on the affidavit allegation is that you collected the money on behalf of them.
My lord, how does my LWA not see merely because the parent court can discharge me? There is no problem. I mean,
Any scan copies of the, on what basis? I have seen the affidavit, but on what basis they have stated this, that we have collected evidence? Can we see the scan copies and all?
yes, still looking,
No, or the case that is, search sheet is filed.
I do not have an idea. I don't think.
So that was also
But at
my,
least
that
now
was my,
161 statement of somebody.
The officer filed an affidavit saying that he is
I was
involved in
responsible.
collecting. From whom, on whose statement? Otherwise, in the FIR, it's specific to 3 district, 3 committees. And
I am a member of the committee.
he is not related to any of the
And at
committees.
that point, I have found the additional.
You are
SP,
somewhere else.
Law and order.
Law and order.
In law, but in law and order.
Law and order. And now the affidavit, the investigating officer says that he collected. But from where we'll have to have satisfaction.
Yes.
Otherwise, we would not have insisted,
Yes.
but his name is not there. There is no specific allegation against him. So to have a satisfaction that a person is not maliciously prosecuted, we want to have it. If something is there, that he is,
I would have argued, my lord, let the case laid down in 227 be applied.
applied.
While framing charge.
Yes.
What are the, I brought up that.
Yes.
Nothing of this one.
So your affidavit says nothing. So can we have the scan copies of the case or case diary? If it's okay, okay.
Can we add another allow with there is. The reports are there, SIT report as well as inquiry report, one internal inquiry.
No, those are the initial stage.
Yes, that is why some seriousness is there.
Mm.
Like this. Because it is not that stage where an affair has been lost
Mm.
on the basis of some relation. No, it is not that. First internal.
No, we have seen this. First
Yes.
initial discrete
Discrete.
inquiry, then thereafter final inquiry, then FIR was filed. And in the FIR, specific allegation is against three,
Responsible for collecting.
there is no disclosure in the FIR.
Right.
Only his name, fix a name in a list that he is also an accused. Now he files now you come with an affidavit saying that he was the collector. But we must have a satisfaction in the given facts that his not name or no specific role is attributed like others. Another aspect of the matter is that you allege that selection was vitiated by corruption. Chairmen are not accused.
Aurobindo,
Chairmen chairmen are not accused. Anyway, we'll not go by all this. We'll see what his allegation is. If any case is there, he'll go there, argue for this at the time of discharge.
So, my only submission therefore is relying on Pepsi and other judgment. But only Supreme Court has said myself, merely because the time court can discharge Even if an appropriate High Court cannot.
Yes, yes, there is no quarrel. There is no quarrel. That's why, but to do that or to do that not on the basis of the affidavit, we cannot do on the basis of the affidavit. There may be much more material against you in the case there.
In fact, I'm facing those two judgments.
There will be much more. So you have the case there.
Not only suspicion, grave suspicion,
Yes,
that's the line.
Yeah.
Thursday, man.
this Thursday.
Let my husband take a chance, man. Otherwise, my.
Thursday, I think so many cases are fixed, and for me, it's criminal cases. It will take some time. I do not think August is possible. 8th of September,
Dividend 7, mother, 8 and not 7.
7th, okay. After perusal of the affidavit filed by the respondent investigating officer, this court is of the view that for proper adjudication, the case diary of the case being which is anti-corruption bureau, SCB police station case number 4 of 2016, registered under section 120B/1 page 2, shall be required. Accordingly, matter be listed on 7th of September
The report, no, reports, no.
2023,
Along with the report.
case diary along with the reports of preliminary report of the SIT be produced before this court on the next date fixed, that is on 7/9/2023.
Time being item number 12.
In fact, these affidavits are not required. What you need to see,
The report should have been annexed.
Annexed.
Have done.
have them.
Have separation see definitely.
Yes, I thought that only a line said that he was the collector. If there's a these are the statements or will produce the.
And we say when it has to be for the court.
Yes,
The last occasion also was to convert court ballot. Here, receive ATS ballot, court ballot, they are set tomorrow.
nothing is in my mind. What was this case?
There was a complaint case filed by the complainant
Hmm.
against master order under section 156 directly to the PS.
Hmm.
That of the order in the state number 15 by law.
Okay, so it was sent to the Nunmati place. What happened thereafter, we do not know. Then therefore you have come for,
Yes, that is because the section that is not that is section 276. And why not they go to the procedure by law. After having been in a relationship for 6 years, which has been admitted in the complaint, the allegation of rape.
oh, that lady. That went for MBA, then studied, stayed in Mumbai, Hyderabad, this. And they stayed for long time together. We have protected you, is not it?
No, my God.
It's a case of,
So I've not been with a party in this particular case. It's a complaint case, otherwise I of course have been with a
but
party.
tell me, have you gone through the complaint?
I have something with a party, I have not been served a copy.
We'll serve you a copy.
But the complaint was filed by them. So,
How far this particular 438 application is maintainable, that is my lord.
there are judgments from the
Because my lord,
Supreme Court, my God. So Sheila Agarwal was-
Why don't you file a quashing of this?
He did, my Lord, but provided he is protected before. the
Will-
harassment
proper
starts.
application, my lord, if they file.
We'll protect her. We'll see the maintainability.
My lord,
See, Mr.
my lord, I am not objecting to my lord whatever. I am only pointing
You
out.
read the complaint,
My lord,
when it started, which year?
2016.
from 2016, a relation started, a switch of this.
The main accused, his brother is the main accused. And in the FIR itself, it says that his brother has assaulted.
What is the case about?
His brother assaulted his wife with a hammer and she died. As per FIR itself, his brother assaulted. He has not assaulted. So also will find FIR page
Case?
That accused number one,
It is solve over. So injuries inflicted by accused number one. You are Sahadev. Case 1-3.
State 14 on 3/1/2023.
By
By the Lion Teacher Mr. Pascal Jana.
what are the offenses? 302.
30.
She died.
She died.
Okay.
Someone was issued and there was no apprehension, therefore he accordingly appeared to the transport to place the flag. And but he was
He was put behind bar by the CJM or by the sessions court, committal court,
by the citizen,
committal court.
and still the main accused is probably.
Where are the statements?
Like my source.
No, tell us what is against him.
In this matter, success.
No, understand.
Yes.
Search sheet is filed on the basis of an
Without getting the FSL report, without getting the PL report. And this person, during the time of investigation, both the accused, the husband of the deceased, and also the other accused, accused petitioner, they were that time, they are not cooperating with the police, they were actually, they stated in the, like, they were this, search sheet, the big fact, I think, tag mark which was there.
but they were arrested.
They were arrested when, when they appeared before the committal court, the person. So what they accused is from him, he received someone and one receipt of someone he appeared, then he was taken to the. He was forwarded to.
No, I want to know. Okay, forget, we understand that he is inside custody. That is not an issue. Issue is what are the materials against him, because now bail is not his right. So we'll have to see what are the materials against him. FIR discloses that it was a single blow by a martel, inflicted by the husband. An allegation against them is that at their instigation. What are this instigation? How that has been done? We want to see from the case diary. That is why we fixed that too. Where are those? What is the basis of framing a search against him? If we find that nothing so is there and any further is there, we will allow him to go on bail. Nothing is there. In your search sheet, nothing is there.
Only the martel is there. That is- that's not-
No post-mortem report also.
Then no postmortem report, FSL report is.
FSL report is also not there. And who are the witnesses that statements has been taken? Any eyewitness?
No idea.
Just go through it, properly go through it and give us. You also go through it. Ahmed, go through it and come at me. And how many methods are there? Shall we start?
For hearing item 51,
So, Mr. This is the special category, top of the list. But Mr. Bhattacharya will do what? When will he be able, how is he doing? Health wise?
My seniors get me given it.
Now, whether he is in a position to do. Okay. Okay. It is submitted that Mr. A.K. Bhattacharya, Learned Senior Counsel, is leading this case and he is not keeping well. Accordingly, matter stands adjourned and be listed on immediately after this 6, 7, 8. Because this is a matter of 2008. 20 September. 28th of September 2023. However, it is provided that if Mr. Learned Senior Counsel is still not in a position to argue this case, the appellant shall seek for alternate senior advocates if so advised. Otherwise, no further adjournment shall be made as this matter is pending since the year 2008. To stop, list accordingly. Yes, you have. But how can you give it? Are you having? Okay, I'll do something. Okay, we'll do something. You flag mark it, whatever you require. Next.
I think 52.
I have denied.
Hmm.
One SRTC.
Can you give a written note, written note of argument? Both of you. And we'll fix it immediately after this holidays. See, from this 376 to coming to, in fact, I was thinking it of releasing it from part third. Subject to what Mr. Nair says.
That is because this matter, a lot has seen it. A lot has heard it, a lot has taken notes. We'll give a written argument. We definitely, fix it for 740, my lord, written arguments.
7. Though matter was heard at some length, the Learned Counsel shall furnish. Matter is next fixed on 7, may not be 7, maybe on 12 possible motion. Not possible. 22nd of September 2023 on the said date.
Before that,
Prior to the said date, the Learned Counsel may file their written note of argument. Okay, then we can summarize and dictate and finish
my
it.
lord has taken, sir, I don't agree in this place. My lord has taken all.
I gave a dictation.
Yes, my lord has taken for all my arguments.
I dictated this.
Both of them.
And it is there.
No? So that is there.
That is
My friend's part also.
there. So, but you give a short
I'll
note.
give a short.
Okay, let us take up the bail now. No other methods. Whichever.
17. 1, 7, 17.
Which list? Why this matter is fixed for hearing? Oh, that case. Some other day. That scrap.
Yes.
Where is Mr. Kamal? Okay, we'll come back at 2. We'll come back at 2.
161 statement is not available. The part is not available. This part is not available. Another fellow also has only one thing, but the idea appeared on the of someone, and I have got
Hard, Mr. Ahmed, Learned Counsel for the petitions. The present application under section 439 and also heard Mr. Swenson application under section 439, the Code of Criminal Procedure 1973 is filed for grant of bail to the petitioner who has been in custody since 18/5/2023. Full stop. The petitioner is an charge-sheeted accused in connection with Sila Pathar PS case number 250/2019 under section 302/34 IPC corresponding to PRC case number 11 of 2023. Full stop. Peruse the FIR as well as 164 statement of the informant. Full stop. Considering the matter available on record, including the aforesaid statement, and also the fact that a summon was issued to the petitioner and he appeared on receipt of summon, this court is of the considered opinion that the detention of the petitioner shall not shall not be necessary, inasmuch as he will have a right to defend himself during the trial. Full stop. Accordingly, present application stands allowed. Bail 25,000 and other bail condition disposed of. Judicial magistrate first. Why do judicial magistrate first class?
On hearing item 56.
Yes, let us hear it. Argo. What is the wrong committed by the appellate court? Appellate court. What was the perversity or wrong by the appellate court?
The court has given the burden so far as the other parties upon the complainant.
Okay, before that, let us come. What are the basis or evidence or deposition which the learned trial court relied to convict the person? Just a minute. PW2. 2 and 3. Now, according to the, don't take it that we are interfering, but nowadays we are also having, we don't have that much of luxury of time. Though it's at 2, only one matter is left, but too many works are other works. So to understand and so that we can deliver quickly. So basically, as far as this court goes, this court's understanding is that this is the allegation, A, B, C, whatsoever. This is the issues to be determined. And these are the ingredients of a section 376. 376 is proved by the evidence of the prosecutrix, PW1. No, just I'm giving an example.
Yes.
Okay, 409. And this has been proved by what is it? That from the material or deposition of so and so, it is established that there was an entrustment. That these are the conditions fulfilled in view of these evidences, PW1, PW2, PW3. Now, which are those materials? Conviction was under what section? 468 and 409. Now, coming to 468, there must be forgery. Now, how forgery was proved? To whom? as per the learned trial court. While learned class concluded that prosecution has established beyond reasonable doubt that this person has forged what? Forged what? Signature of the informant, complainant, signature of the complainant. What are those evidence? First 468.
And divided some parts. What has happened? Some of the vehicles were sold to your mom, your take, so that the principal evidences of those persons owning garages says that he has taken away the vehicle.
No, that is so far relating to 409.
Yes,
That I have entrusted you, you have done without my authority that thing you solely the whatsoever. But how this the case of 468, first let us go to that. How, I am not asking your argument.
yes, sir.
Just I want to know what is the basis or findings of the appellate court. Okay, this is trial court, that so and so, it is established beyond reasonable doubt that so and so by forced signature of so and so.
Other, what has happened, the witnesses, those were examined, the 4, 5, 6, 7, 8, 9, 10. They are from some other DPO. They have called the original record. They have exhibited those documents. And from those documents relating with the investment part, the trial court has held that the accused is guilty.
No, entrustment of accused is guilty. Now forgery,
Forgery and alert, for example, if you logically could see exhibit 22, this was the letter to which he had authorized. And there were 2 different lots, matter.
yes.
In fact, 3 different lots, and there was a release order issued. Those release orders, the complainant has handed over to the accused for getting those, and he has admitted in his evidence that
It is established beyond reasonable doubt that he was authorized to take the vehicle, purchase in auction. He took the vehicle and it was kept in some place. Will that mean a forgery?
No.
I'm on forgery.
That's what I-
Yes.
Now, these orders,
According to you, he forged the signature of the informant and sold his vehicle.
yes,
Now that he forged your signature, how was it? It was taken to be proved by the
my lord,
trial court.
my lord will see exhibit 10.
Exhibit 10. Exhibit 10. Okay, 165. One 165. Yes.
Your lordship sees on exhibit 10 along with exhibit 21 matter.
Yes. Exhibit 21, please.
197.
Yes.
The first exhibit 21 matter.
Page 197.
Yes.
Yes.
This is the release from delivery order gone through, and in the subject has been 396 lot.
Yes.
Now my lord will see on serial number 1. Sale of vehicle, the condemned vehicle, plate number 9 has been sold to Sri Pankaj Sharma. Your lord.
Yes,
Come to column A,
basic value.
in page 199.
What is that? Yes,
Column A, the specimen signature of Sri Avatar Singh, Johar, authorized representative of the party.
where? Page 199.
199, my lord, column A.
7, 8. The specimen signature of Avtar Singh Jorat, authorized representative of the party, are appended below. Okay.
So, my lord, from this blood, it has been given and his signature is instructed. We show that he has been authorized and he has taken over the duty.
Okay.
Now your lordship come. One 67. Column.
Yes.
The specimen signature of Sri Pankaj Sharma network are appended here. This is the signature of that. So, my lord, he has authorized himself
No, there is no quarrel on that. We have admitted that.
and he has admitted.
Yes, no quarrel on that. This was the authorized letter, this proof. Now, how forgery is proved? I want to know that.
This is the forgery. Column number 8 has been changed. So, lordship sees both these pages.
No, that we understand. But how it is proved that this is not his signature?
He has admitted this. In exhibit 10, column 8, these three are his signature.
Okay, it is his signature.
And the
Then,
lordship sees what is written. This, my lord, it is as if this is the signature of Pankaj Sharma, who has been allotted this lot, and by virtue of which, as Pankaj Sharma, he signs documents and so later.
okay, so your case is that the exhibit 10 and exhibit 21 are the same document, but exhibit 10 is a forged document by changing the column 8 by this person, and therefore it is a forgery.
Yes.
This is your case.
Yes.
Now, how forgery is proved to be proved?
So that is what he has interpolated and he has made.
Understand how it is to be proved that this specimen.
This is not the signature of Pankaj Sharma. This is the signature of the accused. The accused himself has made Pankaj Sharma as this signature. And if you lordship would see page 179.
Now, was any forensic report available? Which one is original, which one is forged? Now, why we don't
Then in page 174 minus.
Here from the document, these are two documents.
one?
Exhibit 21, Lordship, kindly see the seal of the official. But actually, in this case, these are all the official documents. What was typed, I was authorized, I went there, I was asked to sign, I have signed it. Now the office, while typing it properly, that has mistakenly written his name as if he was supposed to read it. If your lordship will see the other document by which I have written the other law, my name is the same column, only the name was inside. If your lordship will kindly take it up.
Before that, if the lordship is page 170, just I want to demonstrate before your lordship the modus operandi. Page 170. How this document is related to.
Okay, 178.
Yes. Your Lordship will see, I, Pankaj Sharma, son of so and so, have purchased so and so. And your Lordship sees the signature there in.
Hmm.
And then again, this is form 32, next form 20 at page 1.
Who proved this document?
Collect the officials from the DTO. So these were the records got from the DTO.
What is this exhibit?
Form 12, my lord.
Huh? Exhibit 14?
Yes, my lord. 171 is exhibit. My lord, 170 is exhibit 11. 171 is exhibit 12. 174, my lord. 170, exhibit 13. 176, exhibit 14.
Okay.
Page 181, you'll also see these are also part of the record.
This was a previous share case or GR case?
Here,
Share case.
page 181 is also part of record matter.
Why share case? Just for
He was away, my lord.
Hmm.
And then, my lord, when he came to learn, he said not was an FIR at that point of time. He
when this offense was committed
heard sometime in September 2005,
and when the criminal case was launched?
2006, after 1 year.
After.
Similar, it will also could see. This is
Record. Record. Record.
page 0.
Yes.
To see the regarding lot number 398,
Hmm.
column 1, you are also to see the condemned vehicles of 8 number line has been sold to Sri Avatar Singh.
Hmm. Then
Then my lord will come to exhibit 25 at page 205. This is the letter part of record given to the DTO bond by the purchaser B.L. Agarwala. He says, I will reference to like to request to kindly register vehicle in our name purchased from Avatar Singh.
whose vehicle?
Chassis number you will also could see. It resembles with that.
Where are the chassis numbers?
My lord, the C form, my lord has seen. Chassis number at 205, page 205. Similar at page 13, my lord, exhibit 29.
Who is the trial court judgment? Let us just see one thing. Who is the trial court judgment?
Page 95.
95 the paper book.
Yes, yes.
Okay, let us see the evidences instead of jumping here and there. Now I understand.
Now, just not the thing that- Page number 107. Here, after the issue goes up, then
Point of determination.
determination. At page 102. Number 1 and 2 at page 105.
This page 10. No, 2 is points of finding.
Finding at page 105. That there is no written argument between the accused and the complainant by which it is conclude that the accused was given custody of the 24 number of vehicle 9 in the garage. Therefore, I have no option but to make the testimony of DW1, 2 and 3 and DW1 and 2 in this regard to find out the veracity of their statement. By the way, it is pertinent to mention here that DW1 in his complaint petition and his deposition has specifically stated that he had handed over the original documents of Exhibit 2021, 2024 and 29. This comes delivery order in respect of lot number 396 and 98 to the accused so as to enable the get delivery from the ONGC authority on his behalf. This statement has not been rebutted or questioned by the defense during cross-examination of this witness. This establishes that the original exhibit 10, 21, 22, 20, 24 and 29 are in the hands of the accused. And it was his duty to produce them during cross-examination of PW1 to impeach him regarding the contents of those documents. Since the accused has failed to produce those documents, I have no option but to rely upon the secondary evidence brought on record by the prosecution to official witness. The statement of PW1 is that the accused had taken out all the 24 of his vehicles from the garage with a span of time of 6-7 months, has been corroborated by PW2 and PW3, who are the owners of those garages. Cross-examination of PW2 and 3 reveals that the defense has failed to impeach the credibility or impartiality of these witnesses. There is nothing on record to show that these witnesses have got any animosity or enmity with the accused so as to depose falsely against him or to falsely implicate him in this case. Further, the fact that the accused has admitted that he had taken all those 20 number of vehicles in the garage of PW2 and 3 lends credence to the prosecution case. That apart, since PW2 and PW3 are the owners of those garages, they are the best persons who have the knowledge as to who had taken out those vehicles from their respective garages. The contents of Exhibit 22 has not been denied by the prosecution. As such, it will be safe to rely upon the contents of these documents. More so when the accused had also admitted that he was authorized to leave those vehicles on behalf of the complainant. There is no matter in this regard, that is the signature of the accused appearing in this letter duly attested by the complainant. There is no dispute to this fact that this signature is indeed the signature of the accused, and nowhere in the entire case he has denied this signature is not. I must also point out two numbers of suggestion put to PW1 during cross-examination. In one of the suggestions, it was suggested to PW1 that he had received money from the accused after the accused has sold the vehicle to various persons. This suggestion amounts to an indirect admission of the fact that the accused had indeed sold the vehicle to various persons. Another suggestion was put to PW1 by the defense that on 5/11/2004, he had by a written had authorized the accused to sell the vehicles appertaining to the lot number 395, 96, and 98 respectively on his behalf to various persons. This is also an indirect admission made by the accused that he had sold those 24 numbers of vehicles to various persons. But the accused has failed either exhibit letter dated so and so or produce any other documentary or order evidence to the fact that he was duly authorized to take those vehicles. Point C and D. Before I begin, I must point out that Exhibit 1, 19, 38, and 43 is one and the same release cum delivery order with respect to vehicles of lot number 395. Similarly, Exhibit 10, 21 is one and the same release cum delivery order with respect to vehicles of lot number 396. Similarly, Exhibit 20, 24, 29 is one and the same release order with respect to vehicles of lot number.
Who is the owner of Messrs. B.L. Agarwala?
Well, it's a form, my lord.
Who deposed on behalf of this?
Nobody deposed. Nobody.
Okay.
Well, that has also been taken note of mine. But in the appellate court was of the view it was our burden to bring the witness. Rather, we say not, it was their burden to say from whom he has purchased. Because my obligation is to. No, you will from whom. You should prove it. That's it. But if you also could read this point 3 and 4, so how this has been changed, that you also expected. So that the same documents are appearing. At this stage, it would be appropriate to discuss the contents of Exhibit 2. It would not be inappropriate to discuss the contents of Exhibit 6, 9, 11 to 16, 19 to 21. This has been arranged in such a manner regarding content of each vehicle and 44 respectively, which has been exhibited by the prosecution to PW 4, 5, 7, and 8. These documents relate to registration of some vehicles in various offices of DTO at Guam, Peg, Dibu, Chichagar, and Jarat. Basically, those documents are produced from the custody of the offices where they are supposed to be kept maintained officially. Therefore, the genuineness of the contents of these documents cannot be doubted, more so when the defense has not raised any objections regarding their registration. At this stage, I must relay the evidence of PW4 along with the contents of Exhibit 2 to 9, totally 9 of them. According to the prosecution, the accused has sold the vehicle bearing registration number so and so, according to plot number 396, one N.K. Agarwala of Golaghat. The statements of PW4 reveals that this N.K. Agarwala had applied for fresh registration of this vehicle at Difu, where he had submitted his earlier document, RC insurance. The contents of this earlier RC shows that the vehicle number so and so was registered in the name of N.K. Agarwala. Was registered as NL08A0411 at the office of DTO. However, this vehicle was registered at Difu as vehicle number so and so. There is no doubt to the fact that the vehicle number so and so, so and so, and so and so are one and the same vehicle, because all these documents clearly establish that the chassis number so and so and engine number so the vehicle are one and the same. The question arises as to how N.K. Agarwala got the possession of the aforesaid vehicle when the same belongs to the complainant. At this stage comes the evidence of PW 1, 2, and 3, whose statements reasonably show that it must have the accused who was in the custody of this vehicle who had sold it to N.K. Agarwala. Their statements categorically establish that this vehicle was kept in the garages of so and so, and it was the accused who had taken out the vehicle from time to time. Therefore, a duty was cast upon the accused to explain this aspect of the matter appearing against him. However, he has failed to adduce any oral or documentary evidence in the circumstances evidence appearing in. Similarly, let me relay the evidence of PW5 along with the contents of Exhibit 11 to 16. According to the prosecution, the accused has sold the vehicle bearing registration number so and so of plot number 396 to one B.L. Agarwala of Jorhat. The statements of PW5 reveals that the accused has applied for fresh registration of his vehicle at Jorhat in the name of Mr. Bureau, where he at Form 32, 20, and 29. And accordingly, this vehicle was re-registered at Jorhat. So, vehicle number so and so. There is no doubt to the fact that the vehicles number so and so are one and the same vehicle, because all these documents clearly establish that the chassis number and engine number of the vehicles are one and the same. The question arises as to how BL Agarwala got the possession of the aforesaid vehicle when the same belongs to the complainant. At this stage comes the evidence of PW 1, 2, and 3, whose statements reasonably show that it must have the accused who was in the custody of the vehicle who had sold it to PL Agarwala. Their statements categorically establish that this vehicle was kept in the garage of PW 2 and 3, and it was the accused who had taken out the vehicle from time to time. Therefore, a duty was cast upon the accused to explain this aspect of the matter appearing against him. However, he has failed to adduce any oral or documentary evidence to explain the circumstantial evidence appearing in. Further, the contents of Exhibit 11 to 16 show that it was the accused who had put his signature in Form 32, 20, and 29 as the owner of the aforesaid vehicle in the name of the complainant. This itself is an indirect admission of the fact that complainant is the owner of this. Similarly, let me relay the evidence of PW 7 along with the contents of Exhibit 25 to 27. According to the prosecution, the accused has sold the vehicle bearing registration number so and so, pertaining to lot number 391, BL Agarwala of Jorhat. Statements of PW 7 reveal that this BL Agarwala had applied for press registration of this vehicle at Mon, along with attested signature of the accused as the owner of the vehicle. Accordingly, this vehicle was re-registered at Mon as so and so. There is no doubt of the fact the vehicles number so and so are one and the same, because all these documents clearly establish the chassis number and engine number of the vehicle are one and the same. The question arises as to how PL Agarwala got the possession of the aforesaid vehicle when the same belongs to the complainant. At this stage comes the evidence of PW 1 to 3, whose statements reasonably show that it must have been the accused who was in custody of vehicle who had sold it for the. Their statements categorically establish that this vehicle was kept in garages of PW 3 and it was the accused who has taken out the vehicle. Therefore, a duty was cast upon. And this is the same. Exhibit 25 shows that PL Agarwala has stated that it was the accused from whom he had bought the vehicle. So that in the letterhead, my lord, PL Agarwala has mentioned that was part of the record in the DPO which was activated. Similarly, let me relay the evidence of PW 7 along with the contents of Exhibit 20 to 33. According to the prosecution, the accused has sold the vehicle so and so, lot number 398 to one BL Agarwala of Jorhat. The statements of PW 7 reveal that BL Agarwala had applied for press registration of his vehicle and more, wherein he had submitted his earlier document. However, this vehicle was registered at more than so and so. There is no doubt to the fact that the vehicle number and so and the same, because all these documents clearly establish that the chassis number and engine number of the vehicle are one and the same. The question arises as to how BL Agarwala got the similar lines. Similarly, if your lordship comes to next, further the last paragraph of first, the last two lines, 3 lines of first paragraph. Further, the contents of Exhibit 30 shows that Mrs. BL Agarwala stated it was the accused from whom he had got the vehicle. Similarly, in evidence of PW along with the contents of Exhibit 35 to 37, according to the prosecution, the vehicle is AMS 6109. Same reasoning. And at the bottom, my lord, further the contents of Exhibit 46 shows that BL Agarwala has stated it was the accused from whom he had purchased. Same again, EME at base 111, my lord, AME vehicle number 92213. And you also could see the last 3 lines of paragraph. Further, the contents of Exhibit 46 show that BL Agarwala has stated it was the accused from whom he had bought the vehicle. And my lord, this is regarding next paragraph regarding EME 948. And at page 112, my lord, will see same statements. That who should have been examined, Lord? This has been dealt in para 2 of page 112. In my opinion, the best witness to negate the contention of the accused that it was not he who had sold those vehicles was the aforesaid Mr. N.K. Agarwala or BL Agarwala. And so he had every opportunity to examine these witnesses to prove that the contention of the prosecution is wrong, but he failed to do so, thereby failing to impeach the credibility of the testimony of them. The deposition of PW1 further reveals that after 29/9/2007, he had left Jorhat and gone to Dehradun. That is the delay part of it. He has specifically stated that he had returned back to Jorhat in the last week of August 2005, in the month of September 2005. The defense, except by way of putting suggestion to his witness that it was not so, they had failed to rebut the testimony of PW1 that he was not present in Jorhat for about 1 year and 1 month. In my opinion, this is a reasonable excuse given by the prosecution for delaying lodging the same. It is apparent from the case record that the occurrence took place from the month of November 2004 up to July 2005, that is before the complainant had returned to Jorhat. The present case was filed on 5/10/2003. It is true that there is a delay of 1 year in lodging this case, but the explanation provided by the prosecution to the words of PW1 that he was repeatedly making inquiry with the accused regarding the whereabouts of his 20 number, but it was the accused who was dealing with the matter, and he came to know about the real state of affairs after quite a reasonable period of time. This is, in my opinion, is a sufficient ground for PW1 to lodge in this case at a belated stage. Further, on this count only, the entire prosecution cannot be thrown out if there are sufficient matters on record which establishes the guilt of the accused. Therefore, I hold that the delay in lodging the case is not fatal. There are innumerable judgments of this one could lay down value on the grounds of non-consent. Thus, the evidence on record clearly shows that the accused has fraudulently put his signature in all the documents referred above in the name of the complainant and had sold of the vehicles to various customers without the consent of the complainant, thereby complying with the ingredients of an offense of forgery for the purpose of dealing. This is my view amongst the offense permission.
No case. You have no case. The allegation was clause 8 was changed. According to you, he admits that this is my signature, where clause 8 is forced. The appellate court found and concluded that, see, signature are his, but where is the proof that it has been manufactured by him?
It is an official judgment. In the case below, but he has put his own signature in place of Pankaj Sharma. My lord.
So can we pass a judgment since he is the beneficiary
Yes, my
of
lord.
that signature? Automatically he will be the person who has forced it.
My
Is it-
lord, commitment. It was an official document.
Understand? An official document, there may be mistake by them also.
The lordship will now see the other part. Just 1 minute, your lordship will bear with me. I'll clear it, madam. Can we let us come to case 390?
You take a seat, We'll hear Mr.
Fine.
Clause 8, that clause 8 has been manufactured, inserted by the accused. Where is that proof?
In the circumstances of the fact, because once alert entrustment is given, my lord, I did not.
Now coming to the entrustment, if we go by the document,
My lord.
entrustment, according to the appellate court, entrustment is to take the vehicle and put in a place. He has done it.
That is the.
Beyond that, he has no role.
That is where, my lord, that is where the appellate court has gone wrong.
Hmm.
My lord, the entrustment was to place the vehicles there, to repair it, my lord, and then sell it off.
Hmm.
But he was only entrusted to repair, to keep there and repair those.
There is no document as such.
No document.
Nothing, because entrustment started, your whole entrustment is on the basis of the delivery. Taking from ONGC delivery and then put into ABC place.
Yes.
That is placed. But where is your evidence, unsecond evidence that it was, responsibility was given to him to sell it, repair it and sell it? Where is the evidence?
Not to sell, but what was the purpose for which he was meant to keep the vehicles there, so that it can be repaired and subsequently it could.
Who will repair? Was an entrustment to him to repair? Anything on record?
So that is what we have said in our complaint.
But that is not proved.
And there are judgment which says, my lord, once entrustment is given, lord, in these circumstances, the burden is heavy on the other side to prove, that the burden shifts.
Burden shifts.
So, lord, he
Burden
withdraws
shifts,
that
though,
burden,
no.
lord. The appellate court says it was for me to bring that witness the owner.
Ah.
Whereas the official record shows that the owner also has written in his letterhead that he has purchased it from Avatar Singh. These are part of Form 20, Form 32, your lordship has seen. The two models operandi has been used. But in one of the manner, my lord, he has claimed himself to be the owner by changing the first page, my lord, because the original document was with him, where he claims that it has been sold to him. Therefore, he is selling in his own name. Second modus operandi, that he is Pankaj Sharma, and by putting his signature.
Where is the proof? These are the modus operandi alleged. Where is the proof?
See, this is what has happened.
So let us read the evidence first.
My lord,
Let us read the evidence instead of going to the judgment.
my lord.
Read the evidence of PW1.
I just take 2 minutes to show two things, my lord. If the lordship then can proceed, my lord. Just excuse me for that. My lord, will kindly turn to page 165 and 197. First, I will take your lordship to page 165. 165, the ending portion is 167, that is exhibit A. Let us come to page 165. Thereafter, your lordship will proceed, my lord. Your lordship will see the subject, delivery of condemned vehicle 8 numbers against lot number 396.
165.
Yes, sir.
Yes, delivery of the condemned vehicles, 8 numbers, again lot number 396.
Right, my lord.
Yes.
So it was a delivery challan that I was authorized to collect, which he has given it as exhibit 20. I have collected 22 by. Then exhibit 22 is the page 201. Your lordship, what he is pointing out at clause 8, the specimen signature of Pankaj Sharma, Nehru Park Singer, and I have not put the signature as Pankaj Sharma, I have put it as after saying my. Now your lordship will come in the same type of delivery of the other lot. at
You have
page 197.
signed as Avatar Singh. So
I signed
even if
Avatar Singh.
forgery is of clause 8,
Yes. No, your lordship will now kindly tell to just one moment.
Whose signature is this, my lord?
It is not that I as Pankaj Sharma has signed it. It is what my lord, I have authorized, I signed it. Now your lordship will kindly come to page 197, my lord.
yes.
Then this is the plot, my lord, 396, my lord.
Mm.
If your lordship will see now, my lord, that at page 199. These are all official documents prepared by the office. I have not prepared it.
Mm.
Column 8, my lord.
Mm.
The specimen signature of Avatar Singh Johar, authorized representative of the party, are appended below, my lord. And the seal and signature, if your lordship will see down, manager, MMR, ONGC, M Khaled, and see the seal and signature at the other page, my lord. If you see, it's a different one, my lord.
Which page?
167, my lord.
Just a minute.
So these are two different documents.
Two different.
Officially, my lord.
167.
Yes, my lord. The seal will prove that these are two different documents prepared by the office. I have simply put the signature by the.
Now, whether these officials, manager were called,
Their signature and contents of the document has not been proved at all, my lord. This colleague has not come to the witness box, my lord, to say about this, my lord. And originals were also not produced, only the photocopies were taken into account, my lord. Similar type of photo different or
because it is to be, it would have been sent this letter for forensic.
Yes.
It would have come that this was inserted later on or by different computer. The appellate court said that nothing has been done. So why should we reverse that view?
The original document was in the custody of the accused.
Have you called it? Was search warrant?
No, my lord, is what the modus operandi was, my lord, exhibit 21 is a copy of the original document.
Hmm.
What he does, he manipulates that.
Understand, manipulation is of signatory still of Avatar Singh. Signature is of not Pankaj.
the game, my lord. The under column 8, it is the signature of Pankaj Sharma, which is he has signed under, my lord will see. at exhibit 10.
No.
And by this what he does, exhibit 11, your lordship sees.
Either you then see, suppose clause 8 says
My lord,
specimen signature of Pankaj Sharma.
my lord.
RD is signature of Pankaj Sharma.
No.
These are signatures of avatar.
Yes,
So
my lord.
what is the benefit of this? Because already there is the signature of Avatar Singh is there.
Benefit of this is page 170.
Understand? But the specimen signature of Pankaj Sharma is done.
So that is the benefit, my lord.
Now wherever it is transferred, this Avatar will have to sign as a Pankaj Sharma.
Yes, that is been done at page 170, your lordship sees.
170.
I, Pankaj Sharma. 170, my lord.
170.
Yes.
Okay.
So here there is no execution of the.
Just a minute. So this is a Pankaj Sharma says that I am the owner.
I am the owner.
Now this is the signature of Avatar Singh.
Avatar Singh.
It has been put by Pankaj.
It has been put by Avatar Singh as Pankaj.
Avatar Singh
As Pankaj.
as Pankaj. Right? Understand. Whether this signature was sent to the forensic, who signed it,
That is not been sent.
then what is your case?
My lord, you see page 173.
Neither marked in the photo.
See, your case is so far getting to forgery. What I could understand is, see, I have authorized this man to pick up this vehicle, and since I have authorized, I will have to put his name that this is the person, this is his signature. So only deliver to this man. Okay, fine. So according to you, there is a document which is genuine. That is exhibit 21.
21.
21 exhibit is a genuine document. On the basis of exhibit 21, he has procured or got the delivery of the vehicle. Now, by manufacturing the document, exhibit 10, where instead of Pankaj Sharma, it has been written as Avatar Singh, or what's the vice versa? Vice versa. It has been written as the Pankaj Sharma, but the signature is of Avatar Singh. Now to prove that this allegation, first we will have to prove that this signature is not of Avatar Singh or Pankaj Sharma. Second is that this document, clause 8 is inserted subsequently, is a manufactured document. That is to be proved by the expert. Listen, that as per criminal law, with my limited knowledge, that is to be proved because we are punishing a person on the basis of evidence. Beyond reasonable doubt is to be proved that this is a fake document. Not only clause 8 was inserted subsequently, it will go to the forensic computer who will say that no, this was not done by the same computer because it cannot be. One is official, one is manufactured in outside. So this is not been done by the same, and this signature is put by this man, not signature of original author. It is the signature put by this man with an intention to subsequently also use the same signature in transfer document. Now coming to the transfer document, where is the document? Just now we have shown it.
170.
170. Now suppose holding that this was exhibited, even if it is exhibited 170. Now 170 declares that one Pankaj Sharma issued this letter, but signature is of Avatar Singh, isn't it?
Yeah.
Signature is of Avatar Singh. Now to prove this allegation, you will have to have a proof that these are handwriting of whom and the signature of whom. If that is not there, how you can convict a person?
See at least 170 also.
No, seeing will not do.
But I got what has fallen from your lordship.
Seeing will not do. I can see that, no, this is not the signature. It will not do that. This is onus is upon you that this is the document form 32 was created by Pankaj Sharma. This take the signature of Pankaj Sharma or whosoever. This is not my signature. This signature is put by Pankaj.
No, this is put by Avatar Singh. That is the case.
So this is put by Avatar Singh.
He makes himself malad what he says.
Yes, Avatar Singh.
Yes.
Avatar is the accuser. Pankaj is. Huh? This is done by Avatar Singh. This is done by Avatar Singh declaring Pankaj Sharma. Now, who put this signature as Avatar Singh? He'll have to be proved. Whether it is Jed Kamar or it be, that is to be proved. This is the fundamental of criminal law. I think so.
In these type of cases, there are presumptions also can be done when the burden shift. But I'll demonstrate to some time for responding to that particular. Because once the burden shifts, my lord can presume also.
Where is the foundational fact? Burden shifts when you lay the foundational fact. Where is the foundational fact?
Let the foundation by PW think that they have taken away the vehicle. Now, in this case of
Foundational fact is that beyond taking delivery, you have entrusted other responsibilities. That is the foundation. That foundation is nowhere there. We are wasting time in a case which is, we should not give much more time and we should concentrate on part 2. This matter should go to part 2.
I don't give one opportunity to me.
See, Mr. Dubey, it may feel bad. We don't have that much of luxury nowadays. We don't have that much of luxury that we will continue hearing for 2-3 days. People are inside jail. There is an acquittal. Prima facie, my view is that I have seen the judgment. There is nothing to be, nothing perversity or to change my mind. So this is a case of dismissal.
409 blood, I would like to take some question.
Yes.
I'll have to take it sometime. I will demonstrate.
We'll hear after vacation. The matter stands adjourned on the prayer of Mr. Dubey and be listed after Puja vacation.
Can you see that part of that?
No.
That is the part of my real master of I have left both of them. Said that come while taking permission.
Sometime in September.
Let him take a convenient date, my lord.
Before October, we cannot.
No,
Okay.
whatever date
Okay.
you want.
Okay, October give up a hard at some length, hard at some length. Mr. Dubey submits that he will like to rely on certain judgments on the point of section 409. Accordingly, matter stands adjourned. Release this matter after a month. Oh. I have declared in the air.
No, ma'am is writing so.
Yes, written something. Hard at some length. Mr. Dubey, while concluding his argument, submits that he may be allowed some time to rely on certain judgment on the point of section 409. Full stop. Here is allowed. Release this matter on 5th of October, 2023 for concluding argument of Mr. Dubey and for the argument of the respondents. See, my tentative view, I'm saying, if you can sense me, it's well and good. Two principles.
I have said him the forgery of calculation 409 you better please.
That I'll try to persuade you.
460. Now the question 468, though, I have serious doubt. 469, of course, you can argue that how presumption, what the foundational facts you have laid down. Of course, I am open, still I'm open. No problem on that, changing my views. Because
Last time also you agreed with me when I said the same thing, so we know your lordship is like a open back. We have two cases.
I'm open, no problem on that, but problem is that this case, this type of cases should not get preference. But since we have already spent 2 days, we are keeping it as part, otherwise this type of cases should not get preference on a here, on a day. We take other matters who are inside jails and. Yes. And I have a note prepared. What are your arguments? Short note, that 25 pages argument, short note, bullet points, bullet points. And Purkasta, you also do that. Yeah.